Good afternoon, everyone. I'd like to welcome you to this August edition of In the Boardroom with Attorney Andy Phillips and Attolles Law, brought to you by the Wisconsin Counties Association. My name is Sarah Diedrich Kasdorf. I'm the Director of Outreach and Member Engagement at WCA, and I'm pleased to have the opportunity today to moderate this session as well as to introduce our speakers. Before I turn it over to our group of speakers today, though, I just want to give you a few reminders. First, if you have questions during the webinar, please insert your questions into either the chat feature or the Q&A feature. Our presenters today will be monitoring the chat and Q&A throughout the presentation. If they don't happen to get to your question during the presentation, don't worry, we will get to all of the questions at the end of the webinar. In addition, I just want to remind everybody as well that this webinar is being recorded, and the webinar recording as well as the PowerPoint presentation will be available on the WCA website shortly following this presentation. Another quick note as well is we did make a change to our website to make it a little bit easier for everybody to find these webinars. So if you go onto our website, wicounties.org, all you need to do is click on the tab on the upper right side where it says webinars, and that will take you right to the page where you will find this edition of In the Boardroom, as well as all of our previous editions as well. So with that, today we are going to talk about what can be done when board members act out of line. This must be an extremely important topic, because you'll notice we have 3 attorneys joining us today from Attolles Law. We have, of course, Andy Phillips, who joins us every month. And joining Andy today are Jake Curtis and Rebecca Roker, who have joined us for some of our prior In the Boardrooms as well. So with that, Andy, I'm going to turn it over to you and Rebecca and Jake. I don't know who's kicking it off today, because I know we have a lot to discuss. So Andy,
Thank you, Sarah, and good afternoon, everybody. Welcome to this installment of In the Boardroom. We didn't do this on purpose, but it's kind of amazing that we happen to be on the exact day that the Republican candidates are engaging in their first debate. So when we talk about decorum and we talk about fun stuff that happens in meetings, of course, we get to see it live and in action later tonight, right here in Wisconsin. So this topic comes about because I think that we have seen an increasing amount of, shall we say, zealous advocacy by certain board members that I know Jake and Rebecca and I have all seen at the county board level that I think has increased in intensity over the course of the last 3-4 years. Variety of reasons why. We can debate the whys behind that, but the fact remains that we have this increased zealous advocacy on the part of some board members, and sometimes I think we see some board members stepping across the line. And so we often get asked the question, what can we do? What is there that can be done when we have board members that aren't necessarily behaving well? And so I think today's discussion, like every In the Boardroom segment, is designed to be an interactive process. If you have questions, if you have comments, feel free to share. And I know we've got Conley already saying, just curious at first, what defines out of line? That's a great question, because we're going to get into that concept as well. And sometimes it's in the eye of the beholder. I don't think we have a common definition of out of line. It's in the eye of the beholder. We'll get into that question. And so again, we want to talk through these concepts. It's going to be an open discussion. We're not going to give you a legal treatise on all of these various elements, but we want to essentially give you the tools so that you at least have the ability to think through some of these problems as we get through. So without further ado, when we talk about what can be done, let's talk about what our agenda is for this discussion. We're going to introduce the concept. We're going to talk about some provisions under state law that can be utilized, some provisions under local law. We're going to talk about rules of order, and then we're going to hopefully provide a path forward so that when you are confronting these issues, you at least have the framework so you can analyze these issues on your own to determine what is the best solution for your county. So, as I mentioned before, we often get asked, Attolles, Andy, Rebecca, Jake, please help us. We have a supervisor that's acting out of line. Understand first and foremost, you're not alone. There are many county boards out there. For that matter, village boards, city councils, school boards, other governmental entities that are dealing with this precise issue. And so again, we would encourage you to engage in discussions with your peers all across the state about how to best and most effectively deal with some of these issues. We don't have all the answers as lawyers. We can give you the law, but what is going to work for you is dependent upon the particular circumstances that are confronting you, and essentially what the culture is and what the environment is in your particular locality. So again, as we look at the available options, we of course can give you the legal background, but it's going to depend upon individual facts and circumstances that are prevalent within your county. Anything you want to add on that, Jake or Rebecca, based on what you've seen?
Facts and circumstances are so important. Every situation is different. And as you said, we can give our clients the law, but those facts and circumstances are going to drive every situation.
Yep. All right. So what our presentation is not, it is not a blueprint that is going to define each and every step you need to take when you have a real or perceived situation of a supervisor acting out of line, or for that member, any person in a meeting acting out of line. This is not a one size fits all solution. Each county is different, each board is different, and so the variations are endless. And trying to understand and deal with this just requires some analytical thought. And the purpose of our discussion today is to give you the tools to engage in that thought process.
And keep in mind too, that each county's board rules might be different, ordinances might be different. So even though we have a body of state law, we have different ordinances at play.
Absolutely. So let's start with what we view to be the extreme situation. The extreme being that the question that Conley asked at the beginning, what defines out of line? Well, we know that there is a state ethics code applicable to local government officials. We know that certain counties have ethics codes applicable to local government officials. And so those codes define conduct that is going to be considered out of line with either state statute or local code. And so if we have a member that's engaging in misbehavior, misconduct, so to speak, that rises to the level of an ethics code violation, then we know exactly what is in bounds and what is out of bounds. So very briefly, this whole discussion is not about ethics code violations, but it's important to know because the word ethics gets thrown around quite a bit. There is a difference between what our view of ethical behavior might be and what state law or local code defines ethical behavior to be. So again, let's understand just from a baseline standpoint, what is in and outside that boundary of ethical versus unethical behavior. We've got several categories of prohibitions contained within 19.59 sub 1 of the statutes. That's again the code of ethics that applies to local government officials, and it of course applies to supervisors on a county board. 1A, no county official, a board supervisor, can use his or her office to obtain a financial gain of anything of substantive value for the private benefit of himself, his family, or his or her an organization with which he or she is associated. Second, we've got no county board supervisor can take any official action substantially affecting a manner in which that official, a member of his or her immediate family, or an organization with which the official is associated, in which they have a substantial financial interest. Next, no supervisor can use their position in a way that produces or assists in the production of a substantial benefit, direct or indirect, for the official, one or more of their members of their immediate family, or an organization with which they're associated. And so if you look at these categories of conduct here, just want to point out, your corporation counsel is the resident expert on this. So please, our advice is always, if a situation smells, if it doesn't pass the smell test, have a conversation with your corporation counsel. The reason that we are suggesting that is just because something doesn't smell right doesn't automatically mean that we have an ethics concern. Why? Because you'll see that the terminology that's used within the ethics code is full of ambiguities. What is financial gain to one person may not be financial gain to another. What is substantive value, substantial value for one person is not substantial value for another person. The definition of immediate family doesn't include all of the people that we might consider to be members of our immediate family. Same with the definition of organization. So there are a ton of definitional landmines baked into these statutes that at times can be tricky to navigate. So our advice will consistently be, whenever we have a situation that from an ethics standpoint doesn't smell right, have a conversation with your corporation counsel. That corporation counsel is going to be the expert. Anything you want to add on that, Jake or Rebecca?
So, well, you've used the word ambiguity, and there is many times ambiguity as applied. But another way to think about it is a lot, and this is become frankly more of a pet peeve of mine, when we throw around these ethics accusations against board members. You'll see board members accuse a fellow board member of some sort of ethical violation, and there may be an ethical violation there, but they also may be attempting to weaponize it. And so, to Andy's point about coordinating with your corporation counsel, while there's ambiguity with these terms as applied, they are defined terms. And so, when, let's just take organization, right? That there's going to be statutory definitions as well as case law that we can look to define what it means to be involved with an organization such that you may have an ethical violation. And I say that because we see this all the time. Individuals are involved, they have personal lives, right? So involved with various organizations that may have some sort of connection to a county. And then you may have a political opponent accuse them of having an ethical violation because of that involvement. Well, that's where you got to go to your corporation counsel if this comes to a head, because your corporation counsel is actually going to look at organization. He's going to look at chapter 19. He's going to look at the case. He or she's going to look at the case law, and then actually assist in providing analysis and maybe an opinion relating to whether or not that actually is an ethical violation. Because what we don't want is to weaponize chapter 19. There's severe consequences in the event there is an actual violation. So again, my point is, we've kind of italicized some of these terms, and they're italicized because these are terms that are going to be defined, whether explicitly in chapter 19 or in case law or ethics opinions, that we can look to provide clarity.
And Cynthia asked the question, can organization include the roles they have at local municipalities? Well, your corporation counsel is going to know that in 19.42 of the statutes, which is the definition section, a municipal relationship is excluded from the definition of organization. And that's designed so that we encourage folks to serve on town boards, county boards, city councils, school boards, and so on. And so I'm going to ask Sarah if there is any way that we can rewind this recording when you post it to the website, edit out my use of the term ambiguity, and insert that it is a misconception based upon common everyday conversational utilization of these terms. Because you're right, Jake, these terms, most of them, they're not ambiguous from a legal sense. They are a bit confusing because the way that they are defined legally is a bit different than the way that we might use the terminology in everyday conversation. Fair?
Very much
Okay.
so, yeah.
So Sarah, just do that. Just
But
rewind.
to your credit, though, Andy, I think they are ambiguous to the extent that when we first read them, or when our board members first read them, I know that we've had questions about what is an organization, and we've had clients have some challenging questions with, something that doesn't appear to be an organization indeed was an organization. So, I mean, obviously Jake is correct that we have statutory definitions and we have case law definitions, but I think it is safe to say that they can be ambiguous.
They can be,
So
absolutely.
You're okay.
Thank you.
Yeah.
Jake's point about weaponizing the ethics code, that's a very important point. It was a great segue to our slide here. Because when we're thinking about the resources that are available at our disposal to deal with a situation involving a misbehaving or perceived misbehaving county board member, or somebody that may have engaged in unethical conduct, it's a very serious process. And we don't want to weaponize our ethics code, because given the environment there is a good chance that that weapon could be turned against us. It could be turned toward others. And all of a sudden, we've got a series of 15 ethics complaints that we have to deal with. The enforcement of the local government ethics code in state statute, it's a complaint process with the district attorney. That's a pretty serious situation. If somebody files a complaint against you with a district attorney, I guarantee you're going to lose more than 30 seconds of sleep that night. That's a very serious situation. So we don't want to weaponize that.
Well, and I would just point out from a practical standpoint, in our experience, and this is not a rule, but just kind of in our experience, many district attorneys are going to be hesitant to get involved in a local ethics situation, particularly in a county where you have a corporation counsel who many times is going to know Chapter 19 very well, who is him or herself going to be involved in kind of the local political landscape. They are going to be very hesitant to get involved. And so I think Andy's right. If it ever gets to that level, it really should be viewed as a significant kind of escalation, because your district attorney is not going to want to get involved unless there is very clear evidence of criminal conduct. And even then, he or she may feel that they're conflicted out, refer to a neighboring district attorney or even the attorney general.
Well, and I was going to say, it's the same situation that we've got with corporation counsel, frankly, is that the statutes recognize the ability of somebody who is confronting a situation that involves or it implicates the ethics code to get an advisory opinion from the local ethics committee or board, or for that matter, from corporation counsel, so long as that person follows that written advice. And again, this has to happen prior to whatever action is taken that's being called into question. As long as the person follows that advice, that's the get out of jail free card, if you will. You can't be prosecuted for an ethics violation if you're following the advice from the ethics board or your corporation counsel. And so you can seek a written advisory opinion from the corporation counsel. But the second bullet point that we've got on this slide is an important one. Oftentimes, corporation counsel will be accused of choosing sides or picking sides in a particular ethics situation. It's a really tough position for corporation counsel to be in. I can tell you till I'm blue in the face that corporation counsel has an ethics responsibility that's elevated above and beyond whatever relationships corporation counsel has with various board members. Those ethics responsibilities impact corporation counsel's law license. In other words, they're incredibly serious. As lawyers, we take those things incredibly seriously. That said, that's not going to stop the accusations from flying. I've seen it. So corporation counsel is put in a tough position. So when corporation counsel is put in a position where they don't want to be accused of picking or choosing sides, they sometimes rely on outside counsel to conduct an analysis and provide advice as to how to move forward. We serve in that capacity as outside counsel when corporation counsel says, look, this issue is just, it's too hot and it's too complicated and we can't touch this as our office. So you guys as outside counsel deal with this, which again is fine. We enjoy those assignments and we love helping counties and their corporation counsel out in those circumstances. The problem is you don't have unlimited funds to hire Attolles to provide that type of analysis. And so because you don't have unlimited funds, let's reserve that for only the really, really serious stuff. In other words, let's not use our ethics code as a weapon to try to deal with misbehaving board members unless it is critically necessary. Again, we don't want to weaponize either corporation counsel or the ethics process. It's important to understand too, and people don't necessarily always understand this. I don't care what your ordinance says from an ethics standpoint. One of the remedies cannot be removal from office. There is an entirely separate provision in statutes dealing with removal from office. A violation of the ethics code does not result in somebody's removal from office, nor can it. Any comments on that, Jake or Rebecca?
I guess I would just note Andy's earlier point about kind of the standard that if one seeks an ethics opinion, it's prima facie evidence of compliance with the ethics code. I think that's really important, particularly, we encourage trainings for new board members. That's an example of something that new board members really need to know. They should really have the foundation as to why seeking that opinion from corporation counsel is so significant. I mean, we joke it's kind of a get out of jail free, I mean, very much a joke. But, kind of underlying that is a serious point, and that is, if you have a question and you're struggling with it, I'm on this new committee and I own land in the county and there's a potential project, do I have an actual conflict of interest here? Should I be participating? When in doubt, go talk to your corporation counsel. Because the worst thing that you want to have happen is you don't seek that opinion, you go forward, you cast that vote, you're potentially putting yourself in an ethical situation. You're potentially undermining, a future project that the county may be involved in. And so when in doubt, go talk to the corporation counsel. He or she's going to do the best job they can to give you an opinion. If they can't render the opinion, they're going to talk to us and we'll give that opinion. But at the end of the day, as long as you're following that advice, even if the advice ends up being
Wrong.
technically wrong, you're still in compliance with chapter 19. That is unbelievably powerful. And it's surprising when you talk to supervisors and they don't really even know it exists. And I'm not blaming anybody. It's just one of those teaching moments that we need to tell new supervisors that this is a really important point.
Well, and let me take it a step further, that even if it's not your particular situation, but you're aware of facts or circumstances that could give rise to somebody else's conflict of interest or ethics issue, have a conversation with corporation counsel, because one of the remedies under the ethics code or the conflict of interest prohibitions in chapter 946 is for the court to unwind the particular transaction that was called into question. Well, that's harmful to the county. We don't want to have to unwind transactions. So if you're aware of facts or circumstances that cause you to question what's going on from an ethics standpoint, have a conversation with corporation counsel, because then corporation counsel can take early action to hopefully avoid the need to do something that would unwind the particular transaction. Here's a statute that is on the books that frankly, you'll see the last bullet point. Has this ever been enforced? I don't know the answer to that. And I'd be curious if somebody wants to put in chat or the Q&A if somebody has experience with this, but there's a statute on the books 5915 that simply says a supervisor who refuses or neglects to perform any of the duties which are required of the supervisor by law as a member of the board without just cause, therefore, is subject to a forfeiture of between $50 and $200. Now, you have to have an independent ordinance to enforce 5915, but I don't know that I've ever seen a county enforce an ordinance under this particular statute. Jake, Rebecca, have you ever seen it?
No, I have not.
Again, I don't know what the value of having an ordinance to this effect would be, really, because we're talking about the failure to perform a ministerial duty. In other words, the supervisor doesn't have discretion. The statutes prescribe exactly what the supervisor must do, and the supervisor flat out refuses to do it. But it's a consideration where, hey, have a conversation with corporation counsel to see if it makes sense to put an ordinance on the books. I can't say it does or it doesn't realistically. The ultimate remedy. This is under state law, removal from office. This is the nuclear option. It's the nuclear option of saying, we as a county board believe that this particular member of our board is unfit to continue serving the residents of this county. So we are going to remove him or her from their duly elected office. There are two ways people get removed from office. One of them is a recall. That can happen by the electors who put that particular supervisor there. They can go through a petition process to have somebody pulled out of their office. Second is that the county board has independent authority to remove somebody from office. But I will tell you right now that it is a very high bar to remove somebody from office. Why is it a high bar? Well, because the electors put that person there to represent their interests. And so the legislature recognized long ago when this was drafted, but the legislature recognizing that we don't want to upset what the electors desire, we want to create a high bar for the county board to remove somebody from office. And so you'll see in 17.09, the removal statute, the county board member may be removed by the county board for cause by a vote of 2/3 of all of the supervisors entitled to seats on such board, not 2/3 of a quorum, 2/3 of all supervisors entitled to seats on the board. Cause is defined in 17.001 of the statutes: inefficiency, neglect of duty, official misconduct, or malfeasance in office. That list does not include terminology like I just don't like him or her, or they are acting out of line. That is not in the statutory definition of cause. Cause is defined as inefficiency, neglect of duty, official misconduct, or malfeasance in office. And then if we look at the process associated with removal, 17.16 of the statutes prescribed exactly what we need to do as a county board to remove a fellow supervisor from his or her seat. Has to be based on written verified charges brought by a resident taxpayer. What does verified means? It means they have to sign under oath that the information that they are putting in those charges is true. They are swearing to the accuracy of the information contained within those charges. The supervisor's entitled to a public hearing, and they are entitled to be there personally and by their lawyers. So they have the right to counsel. The hearing has to be conducted with due dispatch. In other words, you can't let this languish for a year or more. You have to act with haste in providing that speedy public hearing to the accused supervisor. It's run just like a trial. It is a mini trial where we have the ability as a county board to issue oaths, issue subpoenas. We take testimony. We have a stenographer record that testimony. And so it looks an awful lot like a court proceeding because it really is a quasi-judicial process. The challenge that we've got is that we don't have one presiding officer here. We have an entire county board of presiding officers. And so orchestrating this entire hearing and entire process, it's critical that we follow all of the steps laid out in statute. Why is it critical? This is a due process proceeding. And whenever we have due process guarantees contained within statute, if we fail to follow them, we might find ourselves on the wrong side of the V in a federal court case. Because if we don't follow these procedures and afford somebody due process, that person is going to claim that we violated their constitutional rights. And we don't want that sort of allegation out there. In addition, think about how this is going to play out in the community. It's a very public process. And so we want to make sure that we dot our I's and cross our T's so that we are providing full due process, not just from the standpoint of not wanting to be sued, but from the standpoint of saying that we are giving everybody the benefit of the presumption of innocence until proven guilty, until we determine as a county board by 2/3 vote, based upon the evidence presented, that that person is no longer entitled to hold their seat because they engaged in conduct that is cause for their dismissal. Last thing I want to point out before I ask for comment from Jake and Rebecca, because we've all been involved in these processes. It's an expensive process. It's not as simple as calling a meeting for 2 weeks from now and just holding a hearing. Again, corporation counsel is put in a difficult position because corporation counsel is typically legal advisor to the board. Well, if the board is going to undertake some sort of investigation and ultimately prosecution to remove somebody, corporation counsel is in a very difficult position trying to prosecute that. They have a conflict. And so it oftentimes involves bringing in outside counsel to investigate and prosecute this particular issue, this particular set of circumstances that may lead to dismissal. Corporation counsel may be a witness. Corporation counsel may have evidence or information that is going to impact the county board's determination. So if corporation counsel is a witness, corporation counsel can't sit as legal advisor to the board. So we need to bring in other outside counsel to sit with the board and advise the board as to the process as the board goes through the cause hearing. And so it is an expensive process, which just leads me to say, let's not use it very much. Okay, let's not, again, weaponize the Chapter 17 process. That said, there are facts and circumstances that lead you to the conclusion that this is incredibly serious and we have no other alternative. So we need to go through the 1709 removal process. If you get to that point, talk to your corporation counsel. Talk to corporation counsel about engaging outside counsel to make sure that we don't inadvertently run the county board and the county into a 1983 claim that somebody's due process rights have been violated. Make sure that we do everything we can to give the community faith in what we are doing. So again, maybe I'll turn it to Jake and Rebecca because we've all dealt with these Chapter 17 situations.
Yes.
Are you serious? So I talked for 10 minutes and you're just gonna say yes?
Well, Yeah, well, we're dealing with one right now, and so my head is kind of swimming with the different comments that we could make. I mean, I would say we could talk for the next hour about this, but I would absolutely agree with Andy that it's significant, and I guess maybe the biggest point in my mind is Andy did a really good job of covering kind of the process under chapter 17, and I don't remember if we have the point in one of the slides, but even prior to that, I would argue one of the most important points is, and this is actually becomes a legal issue in that, we don't want to get too far in the weeds, but there's an additional 7-factor test that you have to meet in order to establish cause. One of those is that, or actually 2 out of the 7, relates to an investigation that has to be done prior to the initiation of the verified complaint. So in other words, in the situation we're dealing with, it's a joint effort between administration and board leadership, knowing that an investigation has to be done correctly, needs to be done objectively. All these factors that Andy outlined, we have in our mind as we're doing the investigation, always being mindful of the fact that we have to have essentially a buttoned up investigation that's going to meet the 7 factors and also these due process guarantees. So even though you're not even there yet, you're still always thinking in terms of, okay, we have this deficiency or this allegation. This is the evidence that we have to support that. And always thinking in terms of the individual is going to have the ability to, for example, cross-examine witnesses. They're going to be able to present their own evidence. So as Andy indicated, this is very much conducted like a trial. And so even before you get to the chapter 17 kind of process and procedures, you're really thinking in terms of a very in-depth investigation. And so just from a practical standpoint, to Andy's point about the cost, I mean, this is significant. Even before the trials, you're going to be spending a significant amount of time, and if it's done correctly, a joint effort between administration and board leadership to establish that investigation, the scope of the investigation, interviewing individuals, reviewing documents and records, and that's all just getting to the point of establishing a verified complaint. Again, I would really emphasize the fact that there's really kind of 2 phases: investigation and then the actual hearing. Both significant, both costly.
Well, and I will say too, Jake, this is going back some years, but I remember we had this chapter 17 issue in the county, and I think your investigative report exceeded 45 pages, didn't it? Single space. I mean, it was a thorough investigation, and the reason we did that.
Interviews.
Yeah, I mean, this is a serious process. Rebecca, I'm sorry, I interrupted.
No, that's okay. So given this is such a public process and an expensive process, do you both think that it is better to wait for a re-election? I mean, every 2 years, or
I don't like that, simply because I don't like kicking the can down the road. If somebody's engaging in conduct that means they ought to be removed from office, I think we have an obligation to address that. Doesn't mean that we have to seek removal, but I think we have to address that conduct. Waiting for re-election can be dangerous in my mind.
And what if a group of citizens decides to proceed with a recall? Can you touch on how other board members could get involved in that process?
Well, I know
that's a sticky situation.
Yeah, I think they get involved in that process. That's more of a practical issue than a legal issue. There's nothing stopping a fellow supervisor from advocating strongly that the recall happen and somebody else be put in office. That's fine, but just understand that if the recall doesn't happen for whatever reason, you got to get along with them. They're going to be a fellow member of the board, and so I think you have to be very careful about just how much advocacy you engage in that process. That'd be my take. Before we move on, because we're going to talk more, couple of questions as it relates to the ethics code. Can the ethics code form the basis for a claim that somebody ought to be removed from office? Absolutely, it can. It depends, again, on the individual facts and circumstances, but it can. Another question: where does sexual harassment come in when it relates to a code of ethics? The code of ethics, unless the local code addresses it, which I don't know that there's any that I've seen that do, the ethics code has nothing to do with sexual harassment. That's a much different class of misconduct that is addressed in either board rules or standards of conduct that are prevalent in the community, in your handbook, whatever case that may be. Next, if somebody's accused of an ethics violation and they go to corporation counsel for an opinion, can they be, and they follow that opinion, can they be charged by the district attorney? The short answer to that is No, because it's the get out of jail free card, but the long answer is it's highly, highly complicated simply because we don't know exactly the facts and the circumstances. So I think going to corporation counsel is incredibly important and a good idea. But understand that there are some steps that you need to go through in order to get that get out of jail free card and make it stick, so to speak. And so we want to make sure that you follow that advice and you speak with corporation counsel early in the process. Pay to play, is that exempt? Exempt from what? Pay to play, it is not exempt necessarily from the ethics code, nor is it exempt from the clause definition. So I think pay to play is a very serious issue, frankly. Definition of clause appears to be limited to acts in their official capacity. Can conduct occur in their personal life that would justify removal? Potentially. I'm not going to say it never can, but if we look at it, if you look at the definition of cause, it's inefficiency, neglect of duty, official misconduct, or malfeasance in office. If their personal conduct impacts their ability to serve, I think you could say there's a causal nexus such that the definition of cause might be met. I don't know exactly how to define the way that it could, but I'm not saying it never could.
Well, and I, to that point, we're seeing, unfortunately, more and more of this. I'm not sure we've had any situations where there was kind of personal conduct that resulted in removal, but we have seen more cases recently where, for example, individuals are going online, presumably in their personal capacity, and using language and statements that just are well below their office, frankly, not personally wouldn't think would be appropriate for anybody to be saying. And
More appropriate for the debate stage tonight than it is for county board proceedings. Is that what you're saying, Jay?
Sure, yeah, let's go with that. But that would be a perfect, is that person, when they're on Facebook at 10 o'clock at night, just using unbelievably inappropriate language against opponents or other residents they may disagree with, are they there in their official capacity? No, but we've had situations lately where that conduct has been addressed, because the point would be, look, when you're an elected official, there's just frankly a higher expectation that you're going to conduct yourself consistent with the county's mission and values, and that has resulted in, I can think of several examples where they actually result in a censure. So not necessarily removal from office, but again, these are not statements made on the board floor. These are not statements made in a department head meeting. These are statements probably when they're sitting on their couch firing off on Facebook, but they still have resulted in censure. The point being, you may be acting in your individual capacity or think you are. We expect more of our county board members, and we expect you not to use this language and to respect your opponents, even if you disagree on policy.
We should expect more from them. Absolutely, 100%, which is the old adage of before you hit send on that email or send on that text message or post on that particular thing, take a deep breath, think about it, because is it really worth it?
Wait 10 minutes. Can I say one more thing?
Go for it.
There was the question before about the code of ethics and how does the sexual harassment component come in? I just wanted to clarify that it, based on what the statutes contain for the code of ethics, that type of conduct or activity doesn't necessarily fall squarely under those chapters of the statute or those provisions of the statute. However, when we're talking about the official misconduct or malfeasance and so forth, that's really where the discussion comes in. And so I don't want the message to be that if, there, again, in the example that was given, if it's either from board supervisors towards others or towards staff, that there's no act or there's no action that can be taken.
No, that's absolutely right.
In light of that.
Because that's often what we get, is that this supervisor is berating staff. This supervisor is horrible to staff. This supervisor is berating fellow members of the board. I mean, what do we do in that situation? That's what I want to get into here in the second half of this discussion, is to talk about the less drastic remedies. We have the ethics code issue. We have the removal from office, both incredibly serious processes, but there are things that you can do to try to set the table for an environment where healthy debate on the policy issues confronting the board can occur. Don't we want a prophylactic so that this never happens? Yes, that should be our goal. So how do we set that up? Well, you can make known that we have the remedy of censure available. that means that if somebody is acting out of line, there's an expectation that we as a board are going to call them out on that and pass a resolution that says you're out of line, you need to conform your conduct to the expected standards for serving on this county board. It's even identified within Robert's Rules of Order. An organization recognized in Robert's Rules has the authority to adopt its own rules and require that members refrain from conduct that would be considered injurious to the organization, its purposes, and I would even say the reputation of the organization. And so what is a censure resolution? It is simply a resolution that says, you did this and it was bad. Don't do it again. Our expectation is that you act better. Now I'm putting it in very, very common terms, but that's all it is a piece of paper that says this was bad. So you might say, well, what is a censure resolution worth? Well, it's a very public document. It's calling that particular member of the board out. It's telling the entire public that this body believes that this member acted out of line. And so we had a question in chat. What about First Amendment concerns? What about the right of the supervisor to zealously advocate for a position? And just because the board thinks it crossed the line, does that mean it crossed the line? And if the board thinks that, doesn't the board have an obligation to recognize that member's First Amendment rights? Great question. Great point, great line of thought here. And we had a Supreme Court decision. Houston Community College System versus Wilson, very recent case last year from the Supreme Court of the United States. That speaks to the concept of censure, because that was the very question confronting the court. Where do we draw the line between an individual's First Amendment privileges and the right of the body to make sure that its affairs are conducted in a very professional way, consistent with the norms that that body has established? Rebecca, you want to talk a little bit about the case?
Sure, Professor Phillips. Yeah, very recent case, which is great.
Wow.
Put me on the spot. Do you want me to stand?
No,
Just kidding.
go for it.
For all you lawyers out there, that's a law school joke. Recent case, which is great for lawyers because we like fresh case law, particularly from the United States Supreme Court. This did not involve a county board, but it involved the community college board of trustees member who, you know, I'm sure in his opinion was a very zealous advocate for his beliefs, and his actions included filing lawsuits against the board, other board members, making very malicious statements and things of that nature. So the board actually did, as you indicated, censured Mr. Wilson, who is the plaintiff. And Mr. Wilson argued that in the act of that censure, the board had violated his First Amendment right to free speech. I don't know if you want to go ahead.
Well, before we go ahead
yeah.
though, because there's an important point on this slide, because those of you who are familiar with Supreme Court cases know that the Supreme Court likes to go way back in time. In that Tyler Hannibal County case, recent case, they went all the way back to the Magna Carta to try to inform their opinion on how the Constitution ought to be interpreted. Well, here, the Supreme Court recognized that since colonial times, the power of assemblies to censure their members was assumed. All right, that's consistent with Robert's Rules of Order, and it's consistent with what we have seen over not just decades, but centuries as it relates to the conduct of assemblies that are gathered for a purpose and the right of assemblies, in this case, county boards, to regulate the conduct of their members. So I'm sorry, Rebecca.
No, that's a great point. And just to touch on that point, when we were looking at, researching our presentation, my question for you was, where in the statutes is censure? And it's not.
It's not anywhere. It's not anywhere in statute. You're not going to find it anywhere.
So no, that's a very good point. So the court recognized that the board of trustees in this instance, or any government body, cannot take adverse action in response to protected speech that would not have been taken absent a retaliatory motive. That is the threshold of when a individual's First Amendment rights occurred.
Yeah, this is the same analysis that applies in any First Amendment case. If there's an employee that claims his or her First Amendment rights were violated, that's exactly the analysis that the court's going to undertake to determine if that employee is correct. So here we've got a member of a board that's claiming my First Amendment rights were violated, and so the court applied the same analysis that it would in any other First Amendment case. And I mean, importantly, the court found that censure is not the same as exclusion from office. Remember what a censure resolution is? Well, it's important to understand what a censure resolution is not, and it's not removing somebody from office. So the question becomes, what's the adverse action? It's simply the body saying what you did is wrong. So therefore, there is no adverse employment action, or at least the adverse action, at least the theory is that there's no adverse action.
And that's where it's key to look at, was the official prevented from doing his or her job? Were they prevented from voting on a particular matter and motion and so forth? So in conclusion, the court held that the censure was not a retaliatory action because, again, Mr. Wilson was not prevented from doing his job. He could still act as a member of the board, and therefore that board was not prohibited from censure. One point that I found very interesting was that the action of censure by the remainder of the board is recognized as a form of speech of those public officials. And so when looking at censure, you really focus in on the conduct as not complying with the purpose and mission and philosophies of the board itself or of that organization itself. And so in this instance, if the other board members were not able to participate in that censure, their First Amendment rights would be violated, which I thought was really interesting.
No, it's true, though. That's entirely true. And I mean, when we look at this, the question I have, and we didn't address it in this presentation because I debated, what goes hand in glove with censure is, for example, removal of committee chairpersonships, removal from committees. The reason I didn't address that is that, I'm sorry, every county does it differently as it relates to committee appointments, committee assignments, and committee chair responsibilities. And so a lot of the question of who has the authority to remove somebody from committees, who has the authority to remove a committee chairpersonship, that's going to depend heavily on your local rules. And that's going to be something that you want to talk to your corporation counsel about. There is no one size fits all for that. There's not even one size fits all principles associated with that. The question I have in my mind is, does Houston Community College System v. Wilson, that's the case, does that case turn out differently if that board had removed Wilson from a committee? I don't think it does, because I don't think there's a vested right for somebody to sit on a committee, but I will tell you this, that if a board rule out there says that somebody can only be removed from a committee for cause, that may trigger due process rights, that may trigger First Amendment concerns. So I'm not going to touch that here. We're not going to talk about it. Talk to your corporation counsel about that. Understand it's a tool that you can use as a threat. If they don't conform their conduct, they may be removed from committees. The exact process you need to follow to do that, please, please, please talk to your corporation counsel about that. What do you guys think? Do you think Wilson turns out different if he'd been yanked from committees?
I do.
You do?
I do, because the court speaks to that, the retaliatory motive and the adverse action they recognize. I think if you go back a slide, is adverse action is generally dismissal from a position or your employment. Depending on how local ordinances read, dismissal from a committee position could be deemed an adverse action or retaliatory motive.
And I will tell you right now, if you're in a county that says that a person serves on a committee at the pleasure of the chair, I don't think you have a case.
But the chair still can't take a retaliatory action, because even when you're serving at someone's pleasure, you cannot there can't be a violation of a constitutional right.
Oh, I understand that, but I don't know that you have a constitutional right to a committee assignment where you serve at pleasure. That would be my point. But I mean, again, we're getting into the weeds a bit on that, but yeah, that's why you need to talk to corporation counsel about that specifically. All right, so how do we set expectations for this? How do we try to do this in a way so that we don't have these issues, so that we have everybody at least having vigorous policy debates, but nothing more, not personal attacks, not berating staff, not berating each other? How do we do this? One of the ways we can do it is through county board rules. And so if we set these expectations within county board rules, we have guidelines that are going to direct people to an accepted set of conduct rules when they sit on the board. And so again, 59.03 of the statutes, the Freedom Statute, that statute gives us administrative home rule authority. We have the ability to organize our affairs at an administrative and local level in a way that we deem fit. And as much as all 72 counties are governed by Chapter 59 of the statutes, all 72 counties do things differently. Why? Because we have 59.03 of the statutes. One of the things that you can do is use 5903 to adopt board rules. And board rules go far beyond just codes of conduct that relate to particular conduct while sitting on the board in a board meeting. But this is a very important component of those board rules. It has the impact of institutionalizing expectations for board conducts. So that way, when we look at the opportunity to censure, we look at other things that can be done as it relates to a misbehaving board member, we not only have the expectation that they will be penalized for engaging in conduct that's outside the norm, we define what the norm is. We say what ethical and responsible and civil conduct looks like. That's contained right within our board rules. I often get the question, should our board rules be codified in ordinance? And over the years, I've gone back and forth on this, to be honest. But I am right now landing on, yeah, I'd like them to be codified. Why? Because that gives them a permanent effect. There's a level of permanence to that where if you're going to change the board rules, you're changing the law. You're modifying an actual ordinance. And it's not easy to modify an ordinance, nor should it be. And so I tend to weigh in on the side of, and I can see the arguments on the other side, I've been there, but I tend to weigh in on the side of let's codify our board rules and ordinance. Jake or Rebecca, did you have particular thoughts on that?
I think board rules are so helpful in the situations that I've seen where there's that questionable conduct by a board supervisor. The board rules become such an important tool, not just to impose some sort of consequence, but to flush out what the expectations are, which goes to your second point. I would also agree with you that codification, I find, is the best rule. I have gone both ways also, and we certainly have counties that go both ways. But I think when it's codified as the law, it is a clear message to all board members, including newly elected board members, that this is our expectation. This is the standard of conduct that we expect as you serving in your role as an elected official. I think that sends a really important message.
Yeah, and I will say this too, is that the last bullet point here is important. We got to remember the hierarchy. Federal law supersedes state law supersedes local law supersedes board rules supersede Robert's Rules of Order. And so if you want your board rules to have the effect of local law, codify them in ordinance, okay? I have this question come up all the time whenever I'm attending county board meetings is Robert's Rules says that a 2/3 vote is required. Well, if your board rules say that a simple majority is required, your board rules trump Robert's Rules. Robert's Rules actually say that your bylaws or board rules can trump Robert's Rules. So again, you have to understand the hierarchy here as it relates to the precedents. So here are some examples, concepts of decorum that you can bake into your board rules. We don't need to go through these in detail. I think they're pretty self-evident. I'm sure there are probably 15 other bullet points that you might want to add to this list, and that's fine. Again, what's the point of this? To set expectations. Here's what we consider to be conduct that is out of bounds. Well, in order to define what's out of bounds, you have to define what's in bounds. And so here are the expectations that we have for our board members.
Can we stop right there?
Yep.
I saw a couple questions pop up, and one instance that I'm asked a lot about is supervisors contacting county staff, going into county departments, asking a lot of questions, asking for documents. Are they outside of their lane? Staff certainly is respectful of the fact that it's a county board supervisor, might be very hesitant or afraid to not answer that request. So what are your thoughts on making a board rule or making a rule saying or limiting supervisors engagement with staff into the board rules?
I personally like to see a process for getting information from staff to the board. Obviously, staff has two responsibilities. They carry out the policy directive of the board. They also provide the board with the information necessary for the board to make an informed policy decision. So that second part is really important. It's a critical function of staff, and I think some supervisors just want to get information from staff to fulfill their responsibility to the public to make an informed policy decision. I get that. Let's have a process though, because employees were not hired to essentially answer questions from individual board members all day long. They can never get their job done, so it's inefficient. If we have a channel for the supervisor to make a request for that information, I would very much prefer that. And then I would like a board rule essentially codifying that procedure. That way, if we have an individual board member who is going to staff repeatedly asking for information, interrupting staff members' workday, then we have the ability as a board to say, hey, you're acting out of line. That's inconsistent with our board rules. Please follow the appropriate procedure for getting information from staff. I would very much prefer that. And I think staff would very much prefer that. Because again, we're defining the boundaries and defining the process. I would love to see that in board rules.
I've even seen that in an employee handbook. Again, because it is an issue that staff sometimes encounters and is a very stressful situation, like you said.
It is stressful because they don't want to
Interferes with their-
disappoint their boss. And
Right.
so, well, why would they? And so if we have a board rule that talks to this process, staff can say, look, let's go through the official process and can you please direct your request through this committee chair or direct your request through the administrator or director, whatever the case may be. Follow that process. It gives staff the ability to say to that supervisor, let's go through the process. No problem getting you the information. Got a lot of stuff I got to get to today, but let's go through that process. All right, so we finally get down in the hierarchy to Robert's Rules of Order. And Robert's Rules of Order has certain elements that help create an environment of proper decorum at the county board level. And again, I'm not going to go through all of these in detail, but I think it's incumbent on every county board chair out there to understand his or her role as board chair and understand that the primary responsibility of the board chair at any board meeting is to maintain decorum and make sure that the body gets to the business that's on the listed agenda. And so you follow these rules, and having that understanding that your obligation, not choice, your obligation is to maintain order. You have several tools at your disposal to maintain that order baked right into Robert's rules. And so if we have persons within the body, within the board that are acting out of line, you have the ability as the chair to call that person out of order. Now, if that person disagrees with your assessment as the chair, I'm not out of order. They have the ability to appeal the ruling of the chair and put it to the vote of the entire board. And if a majority of the board thinks that that person is not out of order, the chair's decision is overruled and that person gets to engage in whatever debate they were engaging in. Fine, I get that. But the board has to be, the board chair has to be the person whose responsibility it is to maintain that order. If the board chair sees a member of the board berating staff, if the board chair sees a person acting in a dilatory fashion in their questions of staff, if a board member sees conversations occurring outside the official debate on the board floor, if the board chair sees any of this stuff, the board chair has an obligation, not a choice, an obligation to bring order back to the assembly to get back to the state of business on the agenda.
So I've been kind of waiting
Go for it.
for this point, because in my mind, from a practical standpoint, these last few slides are frankly the most important. Andy highlighted the hierarchy, right? Federal, state, local, board rules, Robert's rules. That's for purposes of precedent and authority. I think the point that we're making right now is critical, though, from a practical standpoint. It's more important that a chair is adhering or enforcing Robert's rules as opposed to, because we see this, right? We see these debates over the minutia of standing board rules and whether or not they apply. And oftentimes, had a chair, had the board chair or a committee chair simply applied Robert's rules, we wouldn't have even gotten to the point of debating whether or not the standing rule applied. Take it a step back. Look at these basic bullet points that we've been highlighting. Just apply basic Robert's rules, ensuring that a debate is on topic. How oftentimes do we see a debate start with X, all of a sudden we're going to Y, and then it turns into personal, and then somebody says something that offends somebody else, and now we have an ethics complaint. The whole point could have been avoided by simply having the chair step in and say, we're getting off topic, guys. Let's get back to what's been noticed on the agenda. And if we can't do that, we're moving forward. Have a little control. And so I know it's tough. I know it's tough as a board chair to step in and maybe even potentially cut off debate. But I'm sorry, if the debate's not relevant, if the debate's getting personal, if it's getting overheated, use the Roberts rules you have to stop that. And so I guess my note here that I have in front of me that I've kind of been waiting to bring up is, I think we oftentimes see this conflict between, Roberts rules and decorum and ethics. And I think what we're seeing right now, right, again, we have the advantage of working with counties across the state. We see a lot of focus on ethics right now. County Supervisor Smith said so-and-so on the board floor, and we want to bring an ethics complaint. And oftentimes we look at this and we say, why was this even being discussed on the board floor? At some point, the board chair should have stepped in and said, this is not relevant, we're moving on. So again, I mean, I'm not suggesting as a board chair, you want to be this authoritarian, but use the board rules, right? There's precedent across the board. We don't let community members oftentimes speak more than 3 minutes. That's not a violation, right? There's not even necessarily a right to have the public comment, but we control procedures all the time in county board meetings. The same applies to supervisors. And so use those procedures to your advantage. Again, not to stifle the discussion or even dissent, but to focus on what's been noticed, what's in the agenda. And I think by doing that, we can avoid a lot of these ethics situations.
Let me make a quick point too, because you brought up public comment. That's been a particular cause for concern over the last 3 or 4 years, not just at the county level. School boards have seen it, city councils, village boards. There are a particular set of rules and analyses, if you will, that relate to what you can and cannot restrict in public comment. I think people are oftentimes afraid to cut off public comment, afraid to shut down disruptive behavior in the back of the room and things like that, out of fear of getting a First Amendment retaliation claim filed against them. It's beyond the scope of this presentation. And if you want to see that presentation, we'd be happy to have that discussion in the future in the boardroom, but know that there are a lot of tools available to try to, again, bring order to the process. Because oftentimes, Jake, and I know you've seen this too, sometimes supervisors are reacting to the cheers or the jeers that they hear in the back of the room. We don't want that. That should not interrupt the business that's before the board. And so Jake makes a very, very important point, is utilize the tools that we have to try to create an environment where business is taken care of, as opposed to letting it devolve into personal ad hominem attacks against fellow supervisors. We have a question in the chat. What is a model policy or method for supervisors to put in their rule book to get information and have their questions answered about county operations? Great question. I don't have a template. We don't have a model, but I can tell you that addressing this in your board rules is going to go a long way to alleviating concern on the part of the members of the board that somehow they're being kept in the dark about something. They should never feel that way. They should feel like they have access to information. At the same time, staff should feel like they are not going to be bombarded by individual supervisors requesting information every single day of the week. So let's put a process in place that speaks to going through a committee or a committee chair, going through administrator or administration or county executive. I know from an operational standpoint, if the question deals with operations, that ought to be your first call as your administrator or county executive. They're the ones who are in charge of operations. So your policy might speak to having a discussion with your county executive or administrator if you've got one of those two forms of county government. And so again, we're not telling you that there is a perfect policy or perfect procedure. What we're saying is the fact that you have one will go a long way toward assisting in that situation.
Can I ask one question?
Sure.
We're running short on time, but in terms of when the chair is enforcing or taking action to maintain decorum, what are some appropriate acts that a chair could do? Is one of them making a statement within the county board meeting? You and I were recently at a county board meeting where a chair did exactly that. And it was a very powerful moment. So I was wondering if you could comment on that.
Yeah, county board chair can make a statement. Absolutely. Whatever it takes to enforce the rules of order. Absolutely. And I mean, the county board chair could even have a verbal censure of a person's conduct that the county board chair believes is out of line. Again, the body can appeal the ruling of the chair in that regard. Fine. But the county board chair can certainly make a statement like that.
Cool.
Yeah. And so again, to Rebecca's point, we're running overtime now. So what can we do besides invoking these drastic remedies? What can we do? I will tell you, and I have said this for many years, is that it's all about setting expectations. Let's have an honest discussion about decorum. Let's have that discussion at the beginning of every 2-year county board term. Let's set expectations. Let's look at codifying our board rules. Let's look at decorum concepts within our board rules. So again, let's set those expectations and set the table. Rebecca, to your point, public comment by the chair about expectations during debate. We have to respect one another. We don't always have to agree. There is no requirement that we agree, but there is an unwritten rule and a very strong unwritten rule that we respect others' opinions as it relates to policy issues. Suggest EAP for some personal challenges. That's a sticky subject because we get into confidentiality concerns, but that's why we have working with your HR department here on there. There may be people who are struggling for reasons that are just unrelated to whatever led to the outburst on the county board floor. If they're struggling, let's recognize that. Let's help them. We're fellow human beings here. And so EAP may be an opportunity to help them. Again, if you're going to go down that road, I would speak with your HR department or your corporation counsel, probably both of them, before you do that. And so there are plenty of opportunities. And I think the goal here today was, again, to provide you with the tools so that you can evaluate your options as it relates to dealing with what are frankly difficult situations. We have a question with EAP, Employee Assistance Program. It's a confidential way to get somebody help from a mental health, a substance abuse standpoint, something like that, so they can go get that help.
Oftentimes it's part of your health insurance package.
Exactly. So again, provide you with the tools, give you the analytical framework, the options that are out there, work closely with corporation counsel in these options, county board chairs that are out there. You got a job to do. And I'm sorry, it all falls on your shoulders to maintain decorum in the first instance. Okay. If you create an environment and a culture of mutual respect, but a dedication to getting the business on the agenda done and not letting the meeting devolve into ad hominem personal attacks, you're going to be much better off. So it's your job and duty to do that. Those are my parting comments. Jake, Rebecca, anything that you have as parting comments?
No, I mean, I guess to piggyback off of Andy's point, it's tough, but the board chair has a ton of responsibility here, because I think the problem we see is, as opposed to having maybe some uncomfortable conversations, but at least open dialogue, these situations can devolve into just a series of ethics complaints, right? There's an ethics complaint, there's a responsive ethics complaint against the person who filed the original ethics complaint. The next thing you know, corp counsel has 10 different ethics. I mean, we literally have seen this, right? Corp counsel will have numerous ethics complaints, one piled on top of the other, often involving the same group of people. And you get to the point where it's like, and then they have to be responded to, right? I mean, before getting to that point, as the board chair, as the committee chair, work with corporation counsel, maybe have some sort of, forum or something like that to air out these issues before we start filing ethics complaints. So as board chair, take control of that situation. I get it. Sometimes we get to that point where there's an ethics complaint, but far too often I see complaints that, frankly, in my mind, the first thing I wonder is, could this have been resolved simply by a conversation?
I think that's right. And I just had a question. Can we share some of the slides that we skipped over as it relates to these Robert's Rules concepts of decorum? Understand that the entire presentation is going to be on WCA's website, along with the recording of this conversation. So go to WCA's website, wicounties.org, and you can download a PDF version of this presentation to go through it in detail. If you have any questions, comments, or concerns after we get through today, feel free to email us, email the Counties Association. And like I said before, if there's interest in addressing this whole concept of public comment and what can or cannot be done, we'd be happy to address that at a future In the Boardroom segment. Tune in next month. We're going to talk a little bit. I believe it's about construction contracts next month. We've been, for whatever reason, dealing with a lot of concerns surrounding those contracts. So join us next month. But let me end here by saying this. I understand, Rebecca understands, Jake understands. This isn't easy. This isn't simple. And I know you're not getting paid a lot of money. I've seen your paychecks. So you're doing this out of love for your county. And thank you. Thank you for having that interest in county government. But understand that there are resources and people that can help. And so if you ever want to have these discussions, feel free to reach out again to WCA or to us. We're happy to have those conversations. But thank you for tuning in today. Sarah, I'll turn it back to you for any parting comments.
Well, you know, Andy, you just basically said my usual closing comments about everything being posted on the website and previewing next month. So, which by the way, next month's in the boardroom will be held on September 27th. And the topic again, as Andy said, is construction contracts. But with that, I will just thank everybody for joining us today, and we will work to get this up on the website as soon as we can. So
Thank you all. I look forward to seeing you
Thank you.
next month in the Dells.
Yes,
Right.
that too. Right. Thank you, everybody, and have a great rest of your week.